Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. Recently, the Information and Privacy Commissioner of British Columbia issued a decision that essentially shuts down most use of facial recognition technology in the retail context. What's interesting is that the Commissioner undertook this investigation on his own accord. In order to see how prevalent the use of facial recognition was among the province's retailers, the OIPC surveyed 13 of the province's largest retailers, including grocery, clothing, electronics, home goods, and hardware stores. 12 of them responded that they did not use facial recognition technology. The remaining retailer, Canadian Tire Corporation, requested that the OIPC contact their 55 independently owned associate dealer stores in the province. In the result, 12 stores reported using FRT, facial recognition technology. Based on these 12 responses, the Commissioner commenced an investigation under Section 36(1)A of the Personal Information Protection Act of 4 of the locations scattered across the province. What's also interesting is that the stores immediately ceased use of the technology, but the Commissioner determined that doing a full investigation was warranted so that the retailers would be aware of the privacy issues with the use of facial recognition in this context. The investigated stores used 2 different vendor systems, but they essentially operated the same way. The systems functioned by taking pictures or videos of anyone who entered the store as they came within range of the FRT cameras. This would include customers, staff, delivery personnel, contractors, and minors who might have entered the store. Using software, the facial coordinates from those images or videos were mapped to create a unique biometric template for each face. So everyone was analyzed this way. The systems then compared the biometrics of the new visitors with those stored in a database of previously identified persons of interest who had been allegedly involved in incidents such as theft, vandalism, harassment, or assault. When a new visitor's biometrics matched an existing record in the database, the system sent an automatic alert to store management and security personnel that was either via email or mobile device application. The alerts contained the newly captured image that triggered the match, along with a copy of the previously collected image from the Persons of Interest database, and also any relevant comments or details about prior incidents. According to store managers, these alerts were advisory until the match was confirmed in person by management or security personnel. Store management reported that after a positive match was verified, the nature of the prior incident allegedly involving the individual helped determine a course of action. If a prior incident involved violence, management or security staff would escort the individual from the store. If the prior incident involved theft, management may have chosen to surveil or remove the person in question. Now, the legal questions posed by the Commissioner were 1. Whether consent was required under PIPA for the collection and use of images for this purpose. 2. Whether the stores provided notification and obtained the necessary consent through signage or otherwise. And most importantly, 3. Whether this collection and use of personal information is an appropriate purpose under Section 11 and 14 of PIPA. The first question was easy to answer. Yes, consent is required in this context. PIPA, like PIPEDA, requires organizations to obtain consent, either explicitly or implicitly, before collecting, using, or disclosing personal information unless a specific exception applies. Now, no such exceptions applied in this case. Therefore, the Commissioner easily concluded it was incumbent on the stores to show that the individuals gave consent for this collection and use of their personal information. So how would you get that consent? Well, the stores had signage at the entrances. Clear signage is usually sufficient for the use of surveillance cameras, but the question would be whether these would be sufficient for this particular use. Store number 1 had a sign that stated, in part, "These premises are monitored by video surveillance that may include the use of electronic and/or biometric surveillance technologies." The Commissioner said this was inadequate. The notice did not state the purposes for the collection of personal information. Also, stating that biometric surveillance may be in use did not reflect that the store continuously employed the technology. The Commissioner said the average person cannot reasonably be expected to understand how their information might be handled by biometric surveillance technologies, let alone the implications and risks of this new technology. Consent requires that an individual understands what they're agreeing to, and the posted notification failed to adequately alert the public in this case, at least according to the Commissioner. This store failed to meet the notification requirements under PIPA. The second store had a notice that stated, in part, "Facial recognition technology is being used on these premises to protect our customers and our business." This one was also not satisfactory to the Commissioner. The purpose, as set out, is so broad that this statement would relay no specific meaning for the average person. Furthermore, the notice does not explain what facial recognition technology entails or the nature of the personal information collected. One cannot reasonably assume that members of the public understand what FRT is, nor its privacy implications, at least according to the Commissioner. Now, Stores 3 and 4 had better notices, but they still didn't satisfy the Commissioner. Their notices stated, video surveillance cameras and FRT, also known as biometrics, are used on these premises for the protection of our customers and staff. These technologies are also used to support asset protection, loss prevention, and to prevent persons of interest from conducting further crime. The images are for internal use only, except as required by law or as part of a legal investigation. Now, this has more detail, but I don't think it was that well written. It doesn't say what FRT is, and the Commissioner noted that the abbreviation is not well known or widely understood. Using the full phrase facial recognition technology, along with a basic explanation of its workings, would have provided a more accurate description of the store's data collection activities. Even so, the Commissioner said that North American society is not yet at the point where it's reasonable to assume that the majority of the population understands what personal information FRT collects or creates, as well as the technology's privacy implications. All of this would have to be spelled out on the sign. Now, while you may be able to rely on implied consent for the use of plain old-fashioned surveillance cameras, the Commissioner concluded that you can't do that for facial recognition technology, at least not in this context. The Commissioner said facial biometrics are a highly sensitive, unique, and unchangeable form of personal information. Collecting, using, and sharing this information goes beyond what people would reasonably expect when entering a retail store, and using FRT creates a significant and lasting risk of harm. The Commissioner said the distinctiveness and permanence of this biometric data can make it an attractive target for misuse, potentially becoming a tool to compromise an individual's identity. In the wrong hands, the Commissioner wrote, this information can lead to identity theft, financial loss, and other severe consequences, although I'm not entirely sure how. So as a result, the 4 stores were required to obtain explicit consent from customers before collecting their facial biometrics. However, they did not make any attempts, either verbally or in writing, to obtain such explicit consent. So the notices were not adequate, and the stores didn't get the right kind of consent. But the last nail in the coffin for this use of biometrics was the Commissioner's conclusion about whether the use of facial recognition technology for these purposes is even reasonable. Reasonableness under PIPA is determined by looking at the amount of personal information collected, the sensitivity of the information, the likelihood of being effective, and whether less intrusive alternatives have been attempted. With respect to the amount of personal information collected, it was vast. The Commissioner said a large quantity of personal information was collected from various sources, including customers, staff, contractors, and other visitors. The stores reported that their establishments were visited by hundreds of individuals of all ages every day. So during a single month, these systems captured images of thousands of people who were simply shopping and not engaging in any harmful activities. The sheer volume of information collected suggests that the collection was unreasonable, and it was also retained for quite some time. So you won't be surprised that the Commissioner concluded that the personal information at issue was also super-duper sensitive. With respect to the likelihood of being effective, they didn't really have in place any system to measure it. The Commissioner concluded it really wasn't that effective. The Commissioner wrote that before implementing new technology that collects personal information, organizations should establish a reliable method to measure the technology's effectiveness. This typically involves comparing relevant metrics before and after the technology's implementation. However, in this case, the stores did not provide any systematic evidence of measuring their FRT system's effectiveness. Instead, they only gave anecdotal evidence of incidents before and after installation. So without a clear way to measure the technology's effectiveness, it's challenging to analyze this factor, particularly when collecting highly sensitive personal information. The accuracy of FRT technology is also a related issue. Systems such as these have been reported widely to falsely match facial biometrics of people of color and women. The store managers acknowledged that the alerts could be inaccurate and relied on staff to compare database images to a visual observation of the individual. This manual check by staff, the Commissioner said, suggests that the FRT system may not be that effective. false identification can have harmful consequences when innocent shoppers are followed or confronted based on an inaccurate match. Besides the system's accuracy, its effectiveness can also be judged against the existing methods used by the stores to identify potential suspects. The store managers stated that their security guards and managers typically knew who the bad actors are, and they could recognize them without these FRT alerts. The persons of interest were often professional thieves, we're told, who repeatedly returned to the store. Moreover, there's little evidence that FRT enhanced customer and employee safety. Whether a person of interest was identified by FRT or by the visual recognition of an employee, the store's next steps were the same. These involved deciding whether to observe the suspected person or interact with them directly, including escorting them from the premises. In either case, store managers rarely reported contacting the police for assistance. As for whether less intrusive alternatives had been attempted, the less intrusive measures were what they were doing before. The commissioner concluded that the use of FRT didn't really add a lot to solving the store's problems, but it collected a completely disproportionate amount of very sensitive personal information. The less intrusive means, without biometrics, largely did the trick. In the end, the commissioner made 3 main recommendations. The first was that the stores should build and maintain robust privacy management programs that guide internal practices and contracted services, presumably so they wouldn't implement practices such as these that are offside the legislation in his view. The report also makes 2 recommendations for the BC government. First, the government should amend the Security Services Act or similar enactments to explicitly regulate the sale or installation of technologies that capture biometric information. And finally, the BC government should amend PIPA to create additional obligations for organizations that collect user-disclosed biometric identification, including requiring notification to the OIPC. This would be similar to what's already in place in Quebec, where biometric databases need to be disclosed to the province's privacy regulator. Now, I think for all intents and purposes, this shuts down the use of facial recognition technology in the retail context, at least where it's being used to identify bad guys. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions, or if you have any suggestions for other topics to cover on this channel. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.